Okay. Hello, everybody. Today is March 20, 2024, and we're here today to talk about guardianships for grandparents. I have Rachel Kelley from Kalamazoo and Your Path Family Law, and also Sonia Cannon from Birmingham, Michigan at Cannon Law Firm. And these ladies both have worked on a lot of these guardianship cases for grandparents. And the thing that I think is really interesting or important, the reason why we're having this conversation is because this is a really complex area. It really involves the intersection of EPIC, the Estate and Protected Individuals Code, the Juvenile Code, and the Child Custody Act. And these cases often become exceedingly complex. And so I anticipate we're going to have some questions from the audience based on some factual scenarios that our audience members have seen. But I wanted to share a little bit about why I picked this topic in particular. And it was funny because after I did a grandparenting time webinar last year with Blair Johnson and Honorable Shannon Schlegel, Rachel Kelley and I were talking, and she was like, well, you basically told me, Rachel, that you don't usually do grandparenting time motions for your clients who are grandparents because you have found that a better path is through guardianship. So I wanted to let you just share your initial thoughts about like what became the impetus for this webinar. And then we'll jump into the topic, and I know you both have a lot of things to share with us.
Sure. Yeah. Thanks, Lisa. So what I have noticed, particularly on the west side of the state where I primarily practice, which is, Kalamazoo, Van Buren, Allegan, those areas, is that it was becoming increasingly difficult to get the court to enter grandparenting time orders in situations where the grandparents really had been previously raising the children. And so my thought became, well, we need to kind of switch from coming at these cases and getting involved later on in the process, but rather getting involved earlier on in the process when the grandparents would qualify for guardianships, because then I think it sets you up even in the event that the guardianship is terminated because the parents are able to correct the conditions that have led to the guardianship or whatever might occur. It sets you up much better for long-term success with either a custody arrangement or a grandparenting time order.
So you're on the west side of the state, but Sonia's on the east side, and so there's a lot of differences in the practice and what the courts are doing. And I know we're going to talk about some of those differences as we go through the pros and cons of the different types of guardianships. But Sonia, I don't know if you have any like overview comments about your general experience with guardianships for grandparents on the east side of the state.
Yes, and I've also had a couple of experiences from the side where Rachel comes from, and I think based on what I see, it's probably easier to get a guardianship outside there. I mean, I think we need to acknowledge what's going on here in our society. I think we have a huge opioid crisis, a lot of different societal issues that have come up that have caused grandparents to become primary care providers for children. And I think the sad part about it is whether it's a guardianship that you're seeking or grandparenting time, these relatives, grandparents specifically, aunts, uncles, cousins, whatever you may call them, at least from my side of town, it's probably a little more, statutorily driven in terms of you have to be able to specifically be able to say, like, you can't get a hold of this relative. I know we're going to get into this in a minute, but like the courts tend to be very strict about whether or not to grant the guardianship. So if you have kind of grandchildren that are in and out, you might not necessarily get it from my side of town, my side of the state.
Right, got it. So let's talk about, what you do when a client comes to your office in helping them assess what the next step is. And, they might come to you because they say, hey, I want grandparenting time. I want an order for grandparenting time. So what is the first step you take in assessing the situation? And then we'll jump into some specific details about limited guardianships versus an EPIC guardianship. Rachel?
Yeah, so I would say the very first conversation when we have clients who come in with these goals, and I will mention too, I feel like I do a lot of strategy sessions, consultations with people who ultimately were not really going to end up filing anything, but were maybe coming up with a plan for what to do if certain circumstances exist in the future, because they are those grandparents who are used to the kids being in and out of the home based on what's going on with the parent or so on and so forth. So the first step is always going to be, getting sure of all of the players involved, because oftentimes there are not just the biological parents, but there may also be another set of grandparents involved, in, the paternal grandparents versus the maternal grandparents. There may be other aunts, uncles, cousins, family members who previously have been, left to care for this child. And so that's sort of always the first step, is assess all of the parents involved. And then I think the second step after that is the education piece, right? To go through, okay, well, under your circumstances, here are your options and which ones are at the highest likelihood of success.
And Sonia, do you have other things that you like to talk about with the clients when they come into your office?
I think within the same context, one of the things that you have to do on these cases is specifically ask the potential guardian or grandparent, like, what are your goals? Because personally, like, because there are some grandparents that are like, I never ever would adopt my grandchildren. I would never do that. And then there are some grandparents that are like, I'm done with my child. Like, I've been through this with them for 20 years now. I just want to protect my grandchildren and I want to move on with my life. My daughter, my son, let them do what they want. But it's a very emotionally driven legal decision. And it really touches on the core values of the client. So you really got to find that out, what their core value is, where they see themselves headed. A lot of that depends on the age of the child. And the other thing that you have to determine when you're getting the information that Rachel talked about is whether or not their child, meaning the parent, is in support of some sort of a guardianship or grandparenting time order or adoption. And I know that's not today, but I mean, that's a piece of this too. You can do something on that later. But like, so you got to find out, because that's the big issue, right? Like, is this parent going to be willing to cooperate, or are they going to be completely adversarial? Because some of these parents, they don't want to say, like, I don't want to do the parenting. Like, they don't have it in them to say, I don't want to do this. And they feel like the best thing they can do is like fight it, because they're not sure how to say, like, I think this might be in the best interest of my child.
Right. And I think we should address to like the types of when the grandparents are coming into you, what's the situation of the parent that like, you mentioned opioid crisis, Sonia, but is there any other like scenarios like just that you commonly see when the grandparents are like, hey, we might need to do something here because my child, the parent, is X?
Yes. So, like, for me, disability comes into play. Sometimes a child has or a parent has an infirmity that causes them to not be able to parent. I think sometimes young age is a big thing that I see too. You know, you have a teenage parent, and quite frankly, sometimes young age can mean that maybe the parent became a parent when they were 17 and now they want to go to college and they want to go away to college, and they just need some time to get their own life together in order to be a parent in the future. And, like I said, unfortunately, incarceration is a big thing too. And you definitely want to get a guardianship in place when there's incarceration. And like I said, drug, alcohol, and other problems like that. I don't know if Rachel has anything else to add.
Yeah, I think, a situation that I see quite a bit is when you have a parent who dies. And so then you have another parent who was previously not the custodial parent, may not even be the legal parent to the child if the mother dies and the father's paternity was never perfected because the parents were unmarried and, that never happened. Then you may have a situation where you have a child who's pretty substantially in limbo. And I've had several longstanding cases where those situations have occurred.
Well, and in the example that you gave, Rachel, a lot of those parents, the non-custodial parent, were not even very involved, if at all. And So all of a sudden, one parent dies and the children are living with the grandparents. Maybe they were already living with the grandparents before the death, right? And then the non-custodial parent shows up and wants to, assert control, which may or may not be appropriate depending on the facts of the case.
Right.
I think those are the most stressful cases, Lisa.
Well, yeah.
Because they're so hard. Those are really hard. Because right now, the state of the law is kind of like if you're incarcerated, and I'm not making a commentary on the law, but just a general like glean of it is that you might have more rights having been incarcerated than not having been incarcerated at this
Right.
point. Yeah.
Right. I hear you. So let's talk about the different types of guardianship, and we can talk about the pros and cons of each. And because I'm going to just let everybody know, this is going to be a little bit more fluid topic because these cases are very complex and things are happening. They're interweaving with each other during the course of the case. So we're not going to like have, here's limited guardianship 1, 2, 3, here's epic guardianship 1, 2, 3. It's going to be a little bit more mix and mingle because these cases become very complex very fast. And Sonia, you mentioned adoption, and I actually should have mentioned that there are 4 codes and statutes that are intertwined here. And I did not mention the adoption code, and I should have. So you're absolutely right. Adoption is one of the end results that could happen from this, but it again makes everything more complex. So let's talk about if you, first of all, have a preference between recommending a limited guardianship or an epic guardianship, and why. Rachel, do you want to get started?
Yeah, so when we spoke about this in preparation for this webinar, we really noticed a difference between mine and Sonia's preferences, and I think that is based on where we tend to personally get involved in cases. So I'm going to kind of ask Sonia to interject with me, but my recommendation is typically always to seek the epic guardianship because I find the standard in my area is much lower. As we know, the standard for appointment is essentially just that a parent or parents have permitted the minor to reside with another person and don't provide that person with legal authority to care for that minor. And the minor is not residing with their parents at the time of the petition is filing. And obviously there are other rules related to relationship between the minor and the person who's petitioning and things along those lines. But ultimately, that is something that I found has been a very successful way to get a guardianship granted. Sonia had a different perspective, so.
Well, and I think this is to leave it to Liisa Speaker's genius, right? Because she knew how to bring on, right, like 2 totally different aspects, right? My concentration tends to be child protective services. And so I am coming from the viewpoint, I would again look back at what the goal is, because if you're looking at eventually I want to adopt my grandchild or I want to adopt my nephew, right? My experience with the trial court is that they are not going to, and I maybe even the Court of Appeals, I don't know, this is just my personal experience, is that they don't necessarily like the epic guardianship because there's not the rules or the conditions that are placed in a limited guardianship. And so from my perspective, practicing the type of law I practice, I have to see, like, do you want to adopt this child at any point in the future? And if the answer is yes, then I probably would try. Now, remember, we're going to talk about the limited guardianship and that you need the parent's permission. But sometimes what you can do is you can file the epic guardianship and then get to court and make an agreement with the parent on the limited guardianship as a negotiation. But again, it's because of the difference in our practice. And I think that's really important to point out here.
So, I mean, one thing is if a parent just disappears, and I think we've had experiences of that happening, then you may not be able to do the limited guardianship at that moment in time because you don't have an agreement. But that leads me to a question, and either one of you can answer it. But Rachel, you made the comment about how under an epic guardianship, the parent doesn't leave, the children are with the relatives or grandparents or whoever, it could be a neighbor, I guess, and doesn't provide them legal authority. What do they need to do to provide legal authority? Is it filling out a power of attorney? I think I've seen like a handwritten note where they just like have a little letter. I mean, is that good enough to be quote unquote legal authority and if you have that, does that mean you don't go to court for a guardianship? Or is that just kind of bolster your claim for a guardianship?
Yeah, that's a great question. And I think the answer to that is going to be really judge specific, because I think the case law is kind of all over the place, right? I think Liisa knows probably more about that than I do, but ultimately, if there is no power of attorney whatsoever, then my argument would always be, if there's been no power of attorney whatsoever, there's no legal authority, period. Or there's been no a delegation of parental authority, I should say. Either of those things. If neither of those documents exist, then from my perspective, that's a lack of legal authority. Now, I have had cases where judges have denied the right for the guardianship, even without those documents, because they've said, well, especially teenager cases, well, this teenager ran away. So the parent is not the one who left the child in the care of someone else without the authority. The teenager's just refusing to return to their parent. And, my unsuccessful response in those cases have been, well, the parent hasn't come to get their child. They know where they are. They have every opportunity to come get them, and they won't collect them. So, again, that's going to be very specific to your judge, I think.
I love your answer, and I would just add that, like, what I commonly get is my daughter's address is at my home. She's out doing drugs 3 or 4 days a week. She comes home for 1 day and then leaves again. If we do anything legal, she's going to take her kids to her drug user boyfriend's house, right? And so these grandparents are in this conundrum. So, like, what is really being available? And I think it you're right, it depends a lot on jurisdiction and to set expectations with the potential client, right? Like, we can try this, but I can't promise you that this judge is gonna agree. But I think it also goes into that in probate court, what I find is a lot of the forms are very, they're forms, like, a lot of scale forms are used compared to our, family law, right? And I think that's where, like, the art of perfecting an actual attached motion is really important, and to be able to document how this impacts the children, how this impacts the household as a matter of in terms of a words of art, not necessarily the legal aspect.
I wanted to share from the chat, Elizabeth McCree, who's on the southwest side of the state, says she likes to get that power of attorney and have it in place for as a 6-month power of attorney, because that's what her courts in her area like to see in order to get an epic guardianship. What do you do when the parent comes back? Let's say you have one guardianship or another, and we really haven't talked that much detail yet about the limited guardianship and what you can do with it. But if a parent comes back and says they want to take the kids back, and from your grandparents' experience, that this person may not, they might want to come back for a week, but then they're going to change their mind. What happens in court when the parent wants to modify or terminate the guardianship? Rachel?
Oh, that's a great question. I guess it's going to depend on the circumstances of the case, and it's going to depend on the type of case that you have. So my thought process is always, if there is going to be a request to terminate an epic guardianship, but there's a likelihood that the parent really hasn't corrected all of the conditions that have led to their decision to leave their children with someone else, that's a really good time to file a custody action so that the matter can be heard by the family court. And even though the burden of proof is higher in that initial determination for custody, it's how you typically end up with the best result, as opposed to turning around and waiting for a court potentially to catch a parent in a good span of 3 or 4 months. They may terminate a guardianship, and then you're filing for grandparenting time.
So let's talk about that for a minute, because the standard under 722.25, the third party custody statute, says that at this level, the guardian would have to show that, remind me because I haven't looked it up recently, but there needs to be clear and convincing evidence that there'd be a substantial risk of harm, basically, if the child was in the care of the parent, right? There's a parental presumption that is above the established custodial environment of the child. Right. Whereas to terminate a guardianship, we talked about this the other day, the EPIC actually has best interest factors that apply, but apparently only apply to the termination of a guardianship, not to the creation or the modification of one.
Right. Yeah, it's unusual.
And I would just add that the challenge to all of this, especially when you're dealing with the epic guardianship, is that there's no rules for what actually is supposed to create a safe plan for the children to return home. And the other part of it is like these relatives are left to their own means or auspices to try to present to the court. Like, I haven't seen this person in 6 months. Yeah, she moved in or he moved in with this other person. I don't know anything about these people. Like, and at that point, that's where the court appoints, gets DHS involved and has them do an assessment. Usually, at my experiences, before that they would terminate, they would assess the parent. But oftentimes the problem is that people can get themselves together for a short period of time and the kids are bounced back and forth. And I like Rachel's strategy. I think that, while you have the guardianship, especially if you're on that 2-year mark, you need to probably take action and file for custody or adoption. That's how I feel about it.
Sonia, have you done a third-party custody case arising out of a guardianship?
No.
Okay, and that's fine. I wanted you to share, Sonia, a little bit more about limited guardianships and the types of provisions that you like to see in those limited guardianships. And I think the one aspect of a benefit of a limited guardianship is that it creates rights and responsibilities for both parties, right?
Right. So let me correct my record here. I misunderstood your question. Yes. So this is how those cases commonly come up. Let me tell you how I've been involved. And they're so emotional. They're such emotional cases. So the reason that I usually get involved with the third party custody is because I usually represent relatives. So when I represent the relatives, we file for adoption, termination of parental rights, petition to terminate parental rights. And I know I'm getting a little off topic. I'm sorry, Lisa.
No, that's not. It's on
All
topic,
right.
totally.
All right. So when I do that for these relatives, right, I'm the petitioner and, rather than DHS, it's me and the client. Often a very smart attorney that's representing the parents or the parent will file a custody action. So then I end up in a custody action versus a CPS action that was originally a guardianship action. So see the webs that we weave, Lisa. This would be a client that started out with the guardianship, filed a petition to terminate, and then a parent comes in to file custody action. I think it's important to know for anybody that's watching that may want to represent parents, if they're faced with that termination petition or problems with the guardianship and there's no, you can file that custody action as the parent against the guardian, right?
Right. I wanted to say something. Well, first, I was reading a comment from an attendee, and this is probably correct. I keep on saying epic guardianship versus limited guardianship, whereas limited guardianships actually are under epic as well. So I think what I'm meaning, just to clarify, when I'm talking about epic guardianship, I'm just talking about a regular temporary or full guardianship, right? Versus a limited guardianship, which is a very specific statute that creates the rights and responsibilities that Sonia's going to get to in a minute. But I think the reason why it is relevant that termination and adoption are paths from guardianship, because the juvenile code gives that path to guardians when the parent doesn't do certain things, right? So if they violate the limited guardianship plan, there is a path for termination of parental rights and eventual adoption. Or if the parent disappears, for example, for more than 2 years, right? There's that path that's given to us by the juvenile code, even for the limited guardianship. So Sonia, can you talk a little bit about some of the plans that you...
And I don't want to keep repeating this. I think it's just very interesting that Rachel and I have the same strategy, but come at it from a different viewpoint. And again, I do think it just depends on what systems the families are involved in. But a limited guardianship, the like it is because in the CPS world, for example, we have what they call a parent agency treatment agreement. And so a lot of these family law courts and a lot of in the Court of Appeals as well are very sensitive to the fact that parenting your child's a fundamental liberty interest, right? And so when DHS takes a case on, they provide a parent very similar to these parents involved with services, okay? And they say, okay, so the limited guardianship, for example, you'll say the specific parenting time, child support will be delineated, although you can still get child support through the GN case. If they have to do drug testing or alcohol testing, they have to provide proof of that to the court. If they have to do treatment, they have to provide proof of housing, proof of employment, anything that you could possibly want to demonstrate that they're fit to get their kids back is why I like the limited guardianship, because down the road I've painfully learned that the courts feel really compelled by the fact, and as they should be, like it's a fundamental liberty interest, right? They're very concerned when they see situations where parents are not. Yes, that's correct. I saw someone put up a question up there. Those parents must agree that shape of mind. Right. But let me tell you how I like to do it. So I'll file an epic guardianship, right? And then we get into court and the parents there and they see the writing on the wall. Maybe they have attorney, maybe they don't. And then we all sit down and I say, what if we do a limited? Usually parents will agree to that. And they usually will agree to that more than the epic or the general guardianship is what I should call it, because they see it as a path to getting their kids back. And that really sets the family up towards a goal, because remember, guardianships are not long-term permanent plans. Like the courts don't view them, and we're going to talk about this, I'm sure, in a few minutes. They don't view them as something that's supposed to last until the age of 18. Really, it's not envisioned for that. So I like to set a roadmap up through the limited guardianship, and usually either the parents will agree at the onset, they recognize their issue, or if they don't, you got to take them to task like Rachel does, and maybe they're fighting you in court on the general, and you say, okay, what if we do this? And then you get your act together in 6 months, you can have the kids back, right?
So one of the things I was wondering about is the ability for that parent to get parenting time under both types of guardianships, whether it's a full guardianship or a limited guardianship. Rachel?
Yeah, so I have the perspective that the parents can have parenting time under either type of guardianship. I think
The
that
courts award it under.
so that's interesting. I think it depends. I think that and when I say the full guardianship, I'm referring to guardianships pursuant to 700.5204, right? That's the one I'm referring to when Liisa was previously calling the epic guardianship. So what I typically see in those circumstances is I see courts entering very broad orders relative to parenting time, very broad orders relative to child support specifically. Every time you get a guardianship order, it will say child support to be paid at a minimum of $50 a month. That's what's standard in Kalamazoo. That's what I've received over the years. And then if the guardian wants to actually enforce that, they have to go and file the actual child support action to get the friend of court involved so that they can get their child support, at which point they may get more or less depending on all of the calculations under the Michigan child support formula. So I do see those orders happen, and often they'll say parenting time at the discretion of the guardian, but they're not very specific. And I do think that parents would have an opportunity, if they wanted a more specific parenting time order under a full guardianship, to file for that. But what we often see instead of that is a request to terminate that guardianship when parents decide they want parenting time.
Right. And presumably they're asking for time and the guardian's saying, no, you can't have it. Right.
It's so awful. Like, and it's so emotional because, it's this like relatives versus relatives pitted thing. It's very emotional. It's almost worse than divorce, I think.
Usually parent versus child,
Yeah,
in
it's parent
grandparent
versus
cases.
child. And so, the child comes in and says, like, she won't let me see him or her, and the grandparent says, I don't know what happened. My phone broke. I don't have them text messages. She never contacted me. My phone number has been the same. My house has been the same address for years. Like, it's just it's a hot mess is what I call them.
Well, and it's interesting. I don't feel like I see a lot of denial. I think what I see a lot of, though, is you have a parent who maybe hasn't ever really parented, so they don't really understand like structure and a schedule. I see that problem a lot in my cases. So I'm not opposed to parenting time, but she wants to call her 4-year-old at 8 o'clock at night, and that's bedtime. Like, we're in bed. So I'm not allowing that phone call. And now, they're getting chastised for that by the parent who's like, I have rights, I can do this. So, I think maybe that's one reason why Sonia's limited guardianship suggestions are maybe better. But again, they require agreement of the parent. So if you have a parent that's totally absconded, it's not really an option.
So Sonia, can you tell us what parenting time under a limited guardianship looks like?
Well, I think it depends. And also, I want to point out something. Another thing is, depending on your jurisdiction, you have some judges that when you take in a GM case to them and they hear about what's going on in the case, they will say, counsel, if the other parent's not represented, can you work with the parents and mom, do you understand? I'll give you your kids back. Dad, I'll give you your kids back. Can you guys work out an agreement on a limited guardianship basis? And they'll ask you to convert the case. The judge will actually ask you to convert the case, right? And I think you have to be mindful of going for all or nothing, right? When you're in a courtroom, because a judge might be like, I think we need some supervision here. I don't want to give you a GM and this thing takes on a life of its own. And I'm sorry, what was your parenting time?
Yeah.
So, look, it depends what the problem is. It depends what the problem is. Some people have alcohol issues. Some people can abstain from alcohol for 1 or 2 days when they have to visit with their kids, but then they go on binges. Like, I think it depends on what the issue is, but I think the answer would be it could be as much or as little. Okay. I think it depends on the circumstances. So you could have I've had cases where, the parents had biweekly weekends and one dinner a week, or they had summer vacation. Like, I've seen all kinds of guardianships. So depending on the circumstance, you can be as creative as you want.
So
And sometimes that works. It works. It really works. And that's where I think, like, we need a new designation. And this is so off, like, my own opinion stuff, but I feel like there should be like a different guardianship, a relative an RG. I would call it an RG, where you can have it until the kids are up to age 18, and we just all have an agreement. It takes a village to raise a child.
And one thing I wanted to point out was, if there is a parenting time schedule that's created in the limited guardianship, but the parent's not showing up, isn't that potentially a ground to
Oh, it's my
end the
favorite ground to terminate rights on. Failure to visit and failure to support. And let me tell you, like, even if someone's incarcerated or like lives out of state, like, the case law as it stands, like, you could be in prison, and if you make $30 a month in prison working a job, I don't know, maybe $20 a month in prison working the job, you can pay $5 a month to support your children. You can send cards to your children. You can, write letters to them. You can do all kinds of things to demonstrate that you want to visit and support your children. So it doesn't matter. Like, so I think it is it is everyone's number one cause, like failure to visit, failure to maintain contact after 2 years, right? If your goal is adoption, right? But if you're a relative who's like, I really want you to have a relationship with your kid, please call. Like, that's just like in divorce cases. We say, I am sorry, I can't make the parents be parents if they don't want to.
Right. I wanted to share a comment from Kristen Wolfram and point out that she's done a lot of guardianship cases, and a lot of times on behalf of parents. But she made a comment about how, because it's a guardianship case, there's no appointed counsel for the parent. And she's pointing out that the limited guardianship form says that I consent to the suspension of my parental rights. And I actually don't think I've ever looked at that form. And it's a little bit surprising that I would think that you'd have more trouble getting parents to agree to sign that form when they're basically upfront saying that they agree to having their right. I mean, obviously there's a lot of steps that have to happen, but I don't know that they understand that when they're signing the form.
Yeah. And I love parental rights. Like, I'm queen of parental rights here, okay? This is just a different topic, right? Like,
Yes.
I'm all into your, call me if you have a parental right issue, I'll help you. But I think what you have to
Birmingham.
realize, yeah, right. So I think
Got
what you
it.
have to realize, right, is like these are people most of the time, not all the time, because we do have relatives that go in with the wrong intentions, right, Rachel? Like we do. We have some grandparents that are trying to use a system to gain a child of their own, right? But I think that most of the parents that I end up with a relative person is of the parent knows they have an issue, right? They know they have an issue deep down. They know they have an issue, and court is going to be 2 days from now, and they're talking to their mom or dad, and they're like, okay, let's what can we do? And then I say to the grandparent, okay, well, like let them know, like let's come up with this plan. I think yeah, that form is very serious. Should they have a court appointed attorney? Maybe so. I don't know why they don't, you know.
Um, there's another question. I don't know if I understand the question, so I'll just read it out loud. If you guys have a comment, that's fine. Lynn has a client who had a temporary power of attorney with, I think, paternal grandparents, and mom did not take the child back. She says, we fought for custody and ended up with a generous parenting time schedule, and mom stuck with it. So it sounds like she's following the parenting time schedule. Now the kid takes care of the guardians. Any advice on how to proceed? I'm not sure what that means. If is the child now an adult? Do you understand the question?
Or is the child a teenager who's now
Maybe
caring for
some
their
elderly
guardians,
grandparents.
yeah, during that parenting time? Maybe that's how
Maybe.
I might
Yeah,
be
maybe.
interpreting that. I
And
mean,
ordering Amazon all day long and DoorDash on their account, and the and the and the mom, and doesn't like the mom or dad because he or she can do whatever she want at the guardian's home, right? Right,
Well,
Rachel, you see that, right?
I think my comment would be that if it's so the guardianship's based on a temporary power of attorney, right? So that means it's a guardianship under 5204 under EPIC. And to terminate, the grounds to terminate guardianship includes best interest. And maybe this is a guardianship that needs to be terminated or at least modified, possibly.
well, it sounds like they have a custody order because it says we fought for custody.
Yeah.
So I wonder if this is really now
Oh, a
to a
third
full,
party custody
It turned
case.
into a full guardianship.
yeah,
And
if it's a
that
third party
leads
custody
to
case, it's a modification.
didn't you have a comment the other day,
I
Rachel, about this like
did.
hole in the law? Can you explain like what
Yeah.
the concern is?
I feel very strongly that there's a missing piece in the case law and in the statutes relative to what happens when we have an initial establishment of custody under a third party custody case where either by agreement or after litigation with a court, you have entry of a custody order, which in many of my cases is a joint legal custody order for parents and third party former guardians, now current legal custodians with these parents. What is the standard to modify those moving forward? And does the standard change depending on who's trying to do the modification? Because it's not uncommon that, again, these orders might enter and then whatever led to the creation of that guardianship that then led to the creation of that custody order, those circumstances may or may not have changed. I mean, if the issue is substance abuse, as we all know, that's a struggle. Addiction is cyclical. So you can have people who can have, periods where they're really struggling with their addiction, and you can have periods where you're sober and you're doing well and you can show up to be a parent. Or, I have a really long-standing matter where there's just constant issues with domestic violence in the home of the parent. They have a joint physical custody order, but the parent is arrested, every 6 months on a new DV charge with a new partner. How do we deal with that when we come back and do the modification? And so my perspective is that if it's a modification, if the purpose of the Child Custody Act is to try to reduce changes for the children, then it doesn't matter whether the custodian at that point is a guardian or if they're a former guardian or if they're a parent, it's the same standards that would apply. But I've had opposing counsel make alternative arguments that the higher burden of proof still applies for those modifications.
Right. So one comment is, doesn't the case law say that it has to be clear and convincing evidence against a parent on the best interest determination? I think that's true for the establishment of third-party custody, but I don't know that the statute addresses the modification. And does a parent have to, do they have to pass a threshold, or do they get to skip the threshold because they're the parent? I mean, I think it's a little bit unclear right now. And to answer,
Although, Lisa, I want to tell you then I've been doing it wrong, because what I do is after the initial determination, I just revert back to the Child Custody Act. And so I hope that Rachel is right, because that's what I do. And I've never had a problem with it before. Like,
and the practices, I think, like how I might read something may not be actually what's happening in the trial court. So
because remember, the judgment of custody, and I'm sure Rachel knows this as well, can have provisions for drug screens, parenting classes. The judgment of custody can have all kinds of stipulations similar to a limited guardianship. So I just think Rachel's message about, like, you need to keep moving forward and strategizing, don't get stuck on the guardianship, is really, and I like we said, it's such a complicated. Also, after you say what you're gonna say, Lisa, I think Rachel should specifically, because I know that she talked about this the other day, address Kristen's comment about the administrative closure of the guardianship. But I know that I interrupted you, so I'm sorry.
no, that's great.
No, that's okay. I guess my thought process is, obviously these cases are really messy when you have, anytime you have multiple different files that are happening at the same time, when you have a guardianship and a custody case running. And to go back to this sort of question of threshold. So I really do invite everyone, if they believe that there is case law that talks about this specifically in the modification of a custody order after an order of custody with a third party custodian, because my current review of the case law is that it just doesn't exist. It hasn't been taken to the Court of Appeals yet. So maybe one of these days on one of my cases it will be, I don't know, but we'll see. But in any event, yeah, the administrative closure of the guardianship case is certainly something that I know Kristen and I have dealt with in matters where the court has entered an order closing the guardianship. It hasn't maybe done it always on the correct timeline. And I think in my experience in some of those other matters where that has happened, or why that has happened, is because you have judges who really don't understand how the two types of cases interplay with each other, the custody cases and the guardianship cases. Yeah, so Hunter v. Hunter specifically deals with an initial determination, not a modification. I'm very familiar with that. So that's why I'm, that's why I think there's a little bit of a hole in the case law.
Right. And I wanted to point out something, like it gets so messy, and I've worked on these cases too, where for example, if a grandparent goes into court seeking a temporary guardianship, and maybe they get it based on incorrect allegations, maybe they didn't have standing to request a guardianship, but they get it on a temporary basis because the other side, it's ex parte, the other side hasn't had a chance to respond. And a parent, for example, could file an objection pointing out why they don't have standing and have a scheduled hearing on their objection. But before it ever turns into a full guardianship, before the objection hearing happens, they run to circuit court and file a third party custody complaint. And that just shuts down the guardianship case without ever having a hearing on the standing issue. Because if they don't have standing to have a guardianship, they shouldn't be able to go get a third party custody case. But that's another loophole in the law that allows that to happen. And so I think when I was faced with that, I just appealed the third party custody order and talked about the wrong things that happened in the guardianship case. But I think maybe next time I might appeal both if my client has the wherewithal. Like, I would appeal the issuance of a temporary guardianship, even in an administratively closed case, so that I can directly challenge the basis for them getting a guardianship. I'm not sure how that would work. Like, if I won that appeal, that they never should have had a guardianship, then what happens to the third? Like, then what, the Court of Appeals can't order in a guardianship, can't order a circuit court judge in a third party custody case to do something. So it's kind of, it's hugely messy, I guess. And that's what we're finding with a lot of these cases.
And Lisa, though, and again, this is where my difference comes in from a lot of everyone, like general family law, is if you were filing a petition to terminate parental rights, that stays the guardianship. So you generally, what happens is a parent might file a request to terminate the guardianship, and a relative might come to me, and the hearing scheduled, and then I would file a petition to terminate. By the time you get to the probate court, usually the judges say, we're going to wait and see what happens with the CPS case to make any decisions on the probate case.
So tell me, when you have the competing motions, a parent files a motion to modify or terminate guardianship, the grandparents filing a motion to terminate parental rights, and they're both in the same court, right? At this point, that we're not talking about two different cases at two different courts, we're talking about the same court, right?
Well, usually mine are filed in the juvenile court. So, and I suppose you could file it before the probate judge. I don't know if Rachel's ever done that, but usually mine I do under the juvenile code.
But which case goes first? The terminate parental rights case?
The termination of parental rights case.
Right. Okay.
And then usually my experience with the judges in guardianship cases, but also, like, you also, I should very clarify too, you have to get permission to file a petition for termination or adoption. So, or custody, I should say. Yeah, you have to get permission. And usually my experience is time and time again that the probate judges will stay the guardianship, and they'll say, go do your thing in that court and come back. And if the court takes jurisdiction, the guardianship doesn't get automatically terminated from the DHS, like you guys are saying with the family court.
Right. Another thing I wanted to bring up was, and the difference between the two types of guardianships is there like a scheduled review of each of the different types of guardianships to make sure that the kids are still doing well, that maybe to ensure that this is an appropriate guardianship placement, to see how the parent is doing? Is like, tell me, Rachel, is there a process like in the full guardianship context to have court review?
Yeah, so I would say there is a process, but it's not very well maintained, at least in the counties that I primarily practice in. So when you have a full guardianship, the guardian is required to do an annual report of the child. And in my experience, as long as no one has filed anything and your guardian has filed their annual report, the court's not going to hold any type of review. They're not going to investigate any further. They're just going to leave that guardianship alone.
As long as the report's been filed.
As long as the report's been filed,
Right.
and it's a pretty straightforward report. And I've even had clients who've
Is it like a form based?
Yeah, it's a form, and they've been
Okay.
delinquent in filing it sometimes several months.
Yeah.
And still,
Yeah.
the courts don't do much about it. The only time I've ever had a court kind of call everyone in for an ongoing review was when we had a guardian that moved out of state, which they're not supposed to do without the court's permission. So that was the only time that I've seen the court sort of their own volition schedule a review, despite that no one had raised any issues to the court.
And Sonia, with a limited guardianship, I would suspect that there's a more structured review hearing process. No?
I wouldn't say so. No,
Okay.
no, I wouldn't say so. No. No. They do, it also is county like dependent too, right? Because some of the probate courthouses have specific investigators assigned, and they'll actually do every 2 years at the end of the guardianship a report, and for the continuation of it. Mm-hmm.
Now, we haven't mentioned, I do have a couple more questions and I hope we have time for them. We haven't mentioned juvenile guardianships because it was a little bit further outside. I mean, not really though, because I think you've dealt a lot with the juvenile guardianship. Sonia, do you mind briefly like explaining what the difference is with the juvenile guardianship?
Right. So like, I'll give an example scenario. You have a full guardianship. You filed a petition to terminate parental rights. The court takes temporary jurisdiction of the child while your guardianship is in place all this time. So there's dual dual jurisdiction, and the court says, okay, like based on this circumstance, we can't terminate parental rights, but but we also, it's not in the best interest of the child to return back to the parent. And so the court can unilaterally, or not unilaterally, but the court can order over the parent's objection a juvenile guardianship under the juvenile code. The difference between that and an epic or and a limited guardianship, or the general guardianship, I should say, is that the juvenile guardianship are envisioned to last up to the age of 18 years old. So then you get this relief for the grandparent, especially in those courts that don't like to have guardianships piling up in their courthouse, that, okay, I'm at peace now, I have guardianship until they're 18, but that only can be done if there's a CPS or foster care case, as many people refer to them.
And so this is the permanency plan, right? Instead of
Yes,
adoption,
yes,
it's the permanency plan
it is.
for a juvenile
And we've
guardianship.
all accepted that. We're going to stop fighting about the text messages. We're going to
Right.
stop fighting about who's who, and we're going to move on with this permanent thing.
One thing I want to talk about is the situation that the grandparents are in when they before they go in to seek a guardianship, whatever kind it is. I've had cases where the grandparents maybe had they're taking care of their grandkids, and the parents, oftentimes AWOL or incapable of caring for their children, but that grandparent maybe has a past CPS history and is on the central registry, and it could be like 30 years ago, but that I've seen cause an impediment to them being able to keep, when they actually go to get a court order, to keeping the children in their house. Sonia, I know you do central registry expungements, and so I just wanted to, if you had any, thoughts to share about that, like old history, and what to do to help the grandparents if that's a problem.
Okay, so that is something that should not be as big as a problem as it was a couple of years ago, because the law changed, and you're only going to be on central registry if you've been accused of serious physical abuse or neglect or sexual abuse, obviously, that would be. But so a lot of people got naturally taken off of the central registry. So there's a lot of people that had CPS registry situations, they're off now. Now, the people left on it, you have to have been accused of something very serious. And the law has also changed to the extent that now we can review, we can ask the administrative law court to review the registry for those people. We can present new evidence. And that comes up in the context, Lisa, as you know, of like situations where we have like a parent who was on drugs when they were young, but then they got off of drugs. They have a good history now. They're completely recovered. It's been 20 years, but their rights were terminated when their kid was, a young person. So that's where that comes up in. But yeah, there's a way for them to get off, and they should seek legal help for that.
So just to clarify, that if there's an allegation of abuse and neglect that is reported to CPS, you get on the central registry for 10 years, right? And so you're talking about the older cases, those all went away because unless they were at what I would call aggravated circumstances. Or am I misunderstanding? Is that correct? That you still on it for 10 years? Okay.
Yeah, but then there's also what we call the lifer law, right? Like where like certain things like termination of parental rights, you're just gonna be on it forever, right? Like no other, like it's almost like a murder thing for some of these cases, but but I will save my commentary later. But that there's also the lifer part of it as well. So after 10 years, you can ask the court to review it. You shouldn't be on it unless you did something or were found to have done something very serious.
And that means a finding, not just an allegation, right? Like if you've been adjudicated right?
Correct.
Okay. Yeah, correct. Okay. We have a couple of audience questions I want to see if we can get to really quickly before we wrap up. One is, in what situations do you suggest an individual seek a custody order post being granted a permanent guardianship? Like, is there a factual situation that makes it more amenable to, that maybe that's the best route to get a custody order?
I mean, well, I would say the very first time I would say that is if you have a guardian who isn't a grandparent, because then if the parent comes back and terminates, there's never going to be an opportunity for grandparenting time because there's no statute for aunts, uncles, cousins, right? So under those circumstances, I would say if your client isn't a guardian, then you always want to do that. Or isn't a grandparent, you always want to
Right.
do that if they're a guardian. The second place I would say I would recommend it the most is when you see these situations of parent in and out, in and out, in and out of the child's life, because I often find that in those circumstances, it's the relative who's providing the most stability for those kids. And so if, you know, your interest for the child really is stability, then you want to proceed in the custody case.
And then the other question, is there a statutory limitation on how many times a temporary guardianship can be renewed given the 6-month time frame? Wouldn't you just get a full guardian? Like, why would they keep on renewing a temporary? You should get you should have a hearing, right? And get a full guardianship. The temporary is meant to be, I don't, is there a limitation? I don't know. Seems like there should be.
I think that's where you get in the conundrum of these courts saying, like, either the parent's going to get it together or you're going to have to do something about it. And that's where Rachel's custody stuff comes into place, or my termination of parental rights comes into place. Again, just to punctuate, any guardianship is not necessarily planned on being a permanent plan in probate court. That's the real fire over there, is that that's not a permanency plan for any child, whether it's general or limited.
Well, this has been a very enlightening conversation. And yes, I know it's confusing for everybody in the audience. It's confusing every time we work on one of these. It's a complex situation. So I wanted to thank you both for your time today. Do you have any closing thoughts or recommendations for our audience? Rachel?
I just want to say, it's interesting to me how much I learn when I'm supposed to be teaching. So I appreciate all your people that showed up for the training, and I appreciate you and Rachel, and I'm going to keep Rachel's email and bug her all the time.
Yes, I was the best part of this is the two of you met each other.
Yes.
Oh, and I learned stuff too. Thank you.
Oh, okay.
I just want to say, you know, in closing thoughts, I think the chat has been very I would say we've learned a lot here in the chat, and I loved what Elizabeth said about reminding everyone. So I want to make sure everyone sees this, which is that children over 14 can petition and nominate for termination of their parental rights now. And so I think that is important for grandparents to know, particularly in a long-term guardianship situation. It's not something that I've had to face at this point, but it's certainly something to add to your, you know, list of your tools and your tool belt. So.
Yeah, you know, Lisa, there was one more comment that I thought was really good by Elizabeth McCree, and I think it should be noted, because when I file guardianship petitions, she says that, you know, kids, remember that when you're filing on behalf of children 14 and over, those kids can petition and nominate their guardian. And I'm going to tell you, I've had like example, like kids in school, their friends' parents file for guardianship of a child, and that child nominates them. I asked the adult client, the potential guardian, to have the kids sign it, and usually my experience is the courts always go along with the nomination.
Interesting. Wow.
Good.
Well, thank you both for your time today. I appreciate it. I'm going to stop the recording and we can say goodbye to each other.